matrix, was it greenish, more greenish in hue and tone than the other way? I think it was backwards. The real world was like more gray, and the matrix was more green, like it was grass or reality. There's all kinds of signs and signals in there. Okay, deficiency notice. Your paperwork received by the district court legal tech in the criminal division is being returned to you for failure to comply with the following requirements. Now they've got like a multiple choice here. The ones that are not indicated are, it lacks your signature. What would be a problem with a document without a signature? Why would it be null and void? It gives them no authority. They're energized by the signature of the living soul, which communicates with them. So if there is no signature, there is no authority. If there is no authority, they can't see it and recognize it. Second choice, documents filed with the clerk must be original. What's the problem if that isn't met? What happens if you give the court a copy? They get no commercial energy from copies. You've got to give them originals to energize the court to wake them up. Number 3, incorrect or to the state of Alaska court number. Incorrect or no state of Alaska court number. What's wrong if you send them a document with no court number or it's incorrect? It's an inappropriate draft, or it's not serialized to the activity that you want them to respond to. Now, none of those were signed. Number 4 was starred. I'll get to that in a minute. Number 5, a motion for sentence reduction must be filed within 180 days per Criminal Rule 34B1. That's not signed because this document doesn't deal with a motion for sentence reduction. Now, time out. New paragraph. While I'm on that issue, if you haven't read the rules of criminal procedure, you'll see that all rules of criminal procedure, local, state, federal, have provisions post-execution that you can redraft the court for reduction in sentence or execution. So you can allow them to go through their illusion of sentencing the straw man to 1 zillion years on the lot pile, and then come back post when all the public witness dies down and redraft them for something else. Something to consider. It's in all those rules. Okay, new paragraph. On number 4, the one which was starred in this particular deficiency notice, it says that it lacks service on the opposing party. Okay, why is that a notice of deficiency when you send some documentation to the court that lacks notice of filing or service on the opposing party? You have to give the opposing party notice under the rules of procedure. For what reason? It assumes due process and equal protection of law by the minimum requirement of notice and opportunity to respond. And under all rules, civil and criminal, it's the duty of the party that is drafting the court to put service of process on the other party and proof of service by a signed proof of service with the clerk or the party that you've drafted, or else a deficiency notice can be issued. But in this particular document, that was used predominantly as the public excuse for giving him the following additional notice. Because on the bottom of the list is other with a big blank line. And printed in huge font size is the following statement. Bond cannot be released to a fictitious person. Now, what the court is saying here colorably is the documents that you're putting in to the court are not coming from the living God. If the documents going into the court under this guy's acceptance for value, return for value, and drafts is not coming from the living guy, who must it be coming from? The straw man. Now see, here's the problem. Here's where you can give people copies of tapes, copies of paperwork, and they'll take these and think they understand everything in the world and do anything they want. And they'll use perfectly good dead trees and dead ink and throw it at a court and screw it up because they haven't got a clue who they are and what they're doing. Now, well, Victoria's laughing her ass off on the phone. She says, if you read this, you're going to laugh as much as I am. This court, not only once, twice, 3 times, has bent over backwards to tell the litigant that he's acting in the capacity of the straw man and he's an idiot. Now, most patriots will tell you that the public officials, lawyers, attorneys, judges, clerks, are going to give you bad legal advice just to screw you up all the time. In this particular case, these guys can't keep telling this guy enough how badly he's screwing up. And this guy's really cool because he won't learn the first time, doesn't learn the second time, and probably will never learn what it is that they're telling him that he's doing wrong. They're basically telling him, look, we see your paperwork, we can't comment on it, you've got to stop acting as a fictitious person if it's going to work. Now, I said to Victoria, what in the world is this lunatic doing? Well, she said, he put a bond into the court. I said, well, that's good. She said, not the way he put it into the court, it ain't. I said, well, for crying out loud, what did he do? You put a bond in the court, and the case is yours. You're underwriting the bond. He said, well, at the end of the bond is where you sign it, right? Now, what he did is he's got it both ways. Either way, it doesn't make any difference. One way he signed it and he put underneath it without recourse. So there you have it. If it's without recourse, what did he just do to it? He negated the bond, John says. And John, how did he negate the bond by putting without recourse there?
It made the bond negative because when he put that without recourse, that's using UCC 1-207.
Yep, if you didn't hear it on the tape, when he put without recourse, it's UCC 1-207. He made the bond negative because when you put without recourse, it means the one who signed it will not be liable for underwriting this bond. Which means that the only one they can go after now is the straw man. The straw man is their debtor, isn't it? Now, if they go after the straw man to make that bond good, is that negative money or positive money? Negative money. If it's negative money, who owns the case? They do. The public policy is under the case. So when he put without recourse, he basically provided a public liability bond, and then he wants the case title released to the living soul. Hello, the living soul isn't here yet. And we don't know where he is, and we don't know if he'll ever appear. I.e., the bond cannot be released to a fictitious person. Now, that's a colorable statement. And it's absolutely true in the public side, but on the private side, they're also telling them, we don't see you, you're not here yet, you haven't made an appearance by putting your upper and lower case behind a bond that is going to be underwritten by your exemption on the public side. Everybody understand? Now, also, at where you sign the bond, he did file a bond, but another time he put signature refused. Duh! Hello, who's underwriting this bond? Mr. Refused, I guess, is underwriting this bond. Well, we can't find his exemption, so basically there is no bond on the asset side. So how are they going to let him out? Well, in reality, they did let him out of jail. And so they're going, we'll let you out of jail. You may actually think that what you're doing is working. But that doesn't mean you're going to stay out of jail if you keep this up, you lunatic. Okay, now, I said to Victoria, I said, well, holy crow. I said, if he's that screwed up on the bond, what's he been doing in the rest of his case? And she said, oh, you could only just begin to start imagining what's going on. Okay, so what this guy did, and it's not his idea, it's coming from other patriots, it's being taught in these tool seminars, how to get rid of your problems. Okay, first our patriot wrote back to them, and he put it on a non-negotiable notice and demand. And in this he said, commerce operates in truth, and the demand for truth is made on all parties for full disclosure this date of September 1st, 2003. Okay, so this case is going to operate in total truth, right? In their court, you're going to operate in total truth? Are their courts courts of truth? No. What are their courts? Colorable. You don't know the truth. You can't act on the truth. Duh. Okay, we're off and rolling here, man. Now, he says equity under the law is paramount and mandatory by law. So that's absolutely true. Equity under the law is paramount. What kind of equity is he given this court when he demands the truth in their court? He's dishonoring their court. Their court don't operate in truth. So he's in contempt of equity going into that foreign court by telling him he wants them to change their rules. Okay, read the state of Alaska versus this particular person. He starts out his letter and says, who do you want to appear at your hearing on September 8th? And who do you want to respond to your third-party debt collection effort? Demand for full disclosure requires you to advise me who is required to be in the court. My deeded copyright fiction or any derivatives thereof, or the living soul? Duh, who do you think they want in their court? Whoever shows up. Just y'all come on down. We're going to hold a party, and it's immaterial and irrelevant to us. Just show up. You can be either the fiction or the real party. Just y'all come on down, and if you give us honor, we'll give you honor. And if y'all come down and give us dishonor, we'll just be happy to respond in like kind. Okay. Third paragraph. I demand the return of my $1,000 that you required of me to be released from your jail. Excuse me? Who did he just say he was? The straw man. Duh, we're off and running, man. This is going to be a fun appearance. He has no clue. Okay? He probably picked up some paper from the seminar somewhere. Oh, did you mail? Well, thanks, Lynn. You're really helping this dude out. I demand the return of my $1,000. Hey, look, if somebody got out of jail, that was to release the vessel, which is the straw man. That has nothing to do with the personal appearance bond for the living soul. So, why is he arguing the return of the straw man's vessel relief fund? He's defending the defendant. Beep. If you're defending the defendant, you've joined the defense team. If you've joined the defense team and are the defendant, when he's found guilty, you can go to jail in his place. Hello? We're having fun now. Let's get this guy in here. He goes on and says, I have no contract with you. What did he just do? Testify. Who testifies? The creditor or the debtor? The debtor. Strike two. This guy's on a roll. Nor did I ever agree to any terms. Oops. What did he just do now? A refusal. Dishonor. He's not only testifying he's the debtor, he's in dishonor to the court before he even shows up. This guy's really cruising for a bruising. Then he goes, I am not the defendant in this matter. Excuse me? Your actions speak louder than words. You just testified twice you were. I am the creditor of the straw man party to this case. Testify again, you must be the debtor in spite of what you say. Next paragraph. We having any fun yet? This is why the court sends him a deficiency notice to try to get him on point. Hello, are you stupid? Are you crazy? Please be informed that my signature is not attached to your documents, nor any other offers that have been presented. Oh, so he's bragging he's done some non-acceptances then. If you have or think you have my consent in this matter, you are required to prove your claim. There we go. Them there is fighting words. And we're off on a war. Next paragraph. I do not agree to allow the prosecutor for the state of Alaska to trick me into becoming involved in their fiction world. Too late. He already agreed. About 4 or 5 different ways. That was some trick they pulled on him, huh? He wrote a letter and got his foot stuck in the tar baby. Boy, did they have to go out of their way to trick him. I am me, and not that fictitious party you wrote to. In fact, the name da or any derivative thereof is my private property, and I have a copyright placed on it. I'm going to charge them if they use it, even if it is in violation of James 4:11. I will forgive your trespass this time, and this time only. So much for 70 times 7, I guess. That's not written in his part of the Scripture. You get a one-time only break. I hope you give me at least 4 or 5, though, because I've already used them up. Did he get the Cliff Notes Bible? Oh, okay. It was the notes from the seminar. He didn't even go to the actual seminar, okay? He goes on, any future use of my copyright without my express written permission. Is this letter in writing, Caleb? It'll be interesting to see if he actually signed his letter. Yes, he did. He signed it. So I guess he gave him permission. Because of all of the dishonors, he's actually giving him permission. He actually signed this letter without prejudice, too. This is really, no, as this matter is in commerce, all of my common law rights are reserved under UCC 1207, including my right to make myself an idiot. Of course, you realize we're poking fun at this guy, but this is where we were, and hopefully we don't go back again. Now, this guy is going to Victoria's seminar in Alaska. It's about time he needs to go there, all right, okay? She will try to straighten him out. So, I will forgive your trespass this time. Any future use of my copyright without my express concern will cause a violation of the court, and it will be invoiced, and hereby agrees to be invoiced under the copyright contract. See a copy of the contract enclosed. If said invoice is not paid, wonder what he's using for money. Don't know. I will place this court into involuntary bankruptcy. Wow, I think they've already been there, done that. But then they've never been under his bankruptcy before, so that might be different. If you are writing to me, upper and lowercase name, the living soul, then I expect to be addressed correctly, and my mail location be correct, and expect the letter to be written by the de jure court for the de jure court and not the fictitious district superior court of the fictitious state known as the state of Alaska, all capital letters. So this guy's onto it. He knows what's going on. You ain't going to confuse him. He's got it figured out, and he's going to tell them exactly like it is. And then they won't be confused anymore either. He says, my government is composed of sovereigns in the territory wherein I live, and as every man is independent of all laws except those prescribed by nature, he is not bound by any institutions formed by his fellow men without his consent. So move over, King of Babylon, because I'm coming through. This means you, District Court, Superior Court, you were not formed with my consent. You were created through trickery and fraud and without full disclosure of the facts. You know, let's diverge from this for a moment. New paragraph. One of the neater things that Nick Groshinen told me when I was talking with him, he said, I can't tell you how many people give me that old crap about you used trickery, deceit, and fraud, never gave us notice. Think about it. First of all, what we're studying is mostly a lot of their works in which they're telling us the truth every place long before they do it. So number one, they aren't involved in fraud, trickery, and deceit because they're telling you colorably what they're doing. If you don't have eyes to see and ears to hear, that's your problem. But, as our hero in Alaska so eloquently stated, they are not our government. They're a foreign military takeover occupying our land government. Now, being a foreign government, do they have any duty whatsoever to give us any notice at all ever? No. Who gave us notice? The Father. All over Scripture, He gives you notice of what He's going to cause to happen to you when you don't follow and learn His law and put it into effect. So the notice comes from your Father, not from the foreigners. What part of the Scripture have you not read in which He has not noticed us of what was going to go on? Now, how is it that you can claim ignorance and an excuse when the Father has said to you time and time again how the world operates and runs? And if you haven't read His works, if you haven't prayed about its meaning and understood the notice He gave you, why are you blaming the foreign governments, which are just the agents, carrying out what the Father told you He was going to give them the power to do? Don't you understand? Once again, the patriots are looking to use the tools to loosen the wooden yoke under the stupid presumption that it's the foreign military government that put the wooden yoke on them. It was the Father that put the wooden yoke on them, locked them up in the corral, and the foreign governments and military governments were just sent here to peruse the perimeter of the corral and make sure the doors stay shut. That's all they're doing. New paragraph. Our friend goes on and says, you were created through trickery and fraud without full disclosure. You utilize deceptive trade practices to gain jurisdiction where none would otherwise exist. The court is a mere corporate fiction, a piece of paper existing only in the mind through the art of deception. Well spoken, our faithful and knowledgeable prophet. You only have one problem. That speech wasn't sent from the Father to be given to them. So you're going to have some difficulties. Next paragraph. I am not a corporation. I am a real, living, breathing soul, a child of my Father Yahweh. You, the District Court, Superior Court, are a corporation, a fiction, and you do not exist. You do not have my permission to ever attempt to recontract me again, whether verbally or in writing. Next paragraph. I take, well, Caleb, I'm glad you recognize this is going to stop him. Why, he's spreading out the holy water and everything else here, which is going to stop them right in their tracks. They're going to see that they're illusions, that they're fictions, that they have absolute, they may even hire them to come in and give some seminars to their employees so they'll all know their limitations. Next paragraph. I take title to the matter. Haven't seen it happen yet. He's trying very hard to get a title in the matter, but I don't think his title's going to be what he's looking for. This is my title, property, matter, number, and then he puts down the court case number. Yes, he do. No, he doesn't. He puts down a different number. It's his private number. Okay. Next paragraph, underline it. Underline, bold, and in italics. This one stands out. This is going to be the coup de grace. This is the important one. This is where they're going to really get the message. Your offer of contract in your cash bond of August 16, 2003, and your order and conditions of release of August 16, 2003, for jurisdiction for making a legal determination for me in the above is hereby rejected and returned to you undersigned under Truth in Lending and Fair Debt Collection Act. If you, name of the party in the government, or your doing business as, name of another government officer, or any third-party agents, think or assume you are representing me, those are the attorneys, you are fired. I told you that was the biggie. He's got complete control now, right? Next paragraph. Oh, it's all in, like I said, it's underlined, it's in bold, and it's in italics. It's everything, man. This is the heart and soul. I have now got title to my case back. Oh boy. Is what true? Is this a true letter written by this idiot? Yep, absolutely. And he actually studied under some other patriots that know what they're talking about. Yep. Well, he studied under some other gurus. They know. Because you don't want to contract with these people in a foreign venue. You'll be in big trouble, man. So what if you're already in their corral under their wooden yoke? You wouldn't want to get deeper into the contract, would you? That's right. He has an army coming to break him out. The army is called terrorists. Notice, next paragraph, notice to the agent is notice to the principal applies to this notice. Notice to principal is notice to the agent applies to this notice. Last paragraph. Something pursuant to Title 28, United States Code, Section 1746, subparen, I think 1, this first day of September 2003, with full reservation of my entire natural creator God-given rights, without prejudice as preserved by the state and federal constitutions. He's pulling out the big guns now. Those are the ones that got us into debt to begin with. Yeah, the ones that are irrelevant anymore. As this matter is in commerce, all of my common law rights are reserved under UCC 1-207. This document was created by addressee. upper and lower case. And then he's got the straw man's name and all derivatives thereof by my copyright, and then he signs it upper and lower case addressee. So he's got a good signature on that puppy. Now remember, this document went in before he actually returned the bond. And, okay, here's another document sent by our hero to the district court, the fictional district court. Yeah, if he wasn't headed for jail, this would be Huber's. This is his document called Order to Discharge, pardon, close, and expunge title property under his account number. Now, equality under the law is paramount and mandatory by law. The good news is he's going to get equality. The bad news is he's going to get equality. Okay. I, upper and lower case, the living soul, who bleeds, will probably, born under God's, titled sovereign, incompetent to handle all of my affairs. It's a little bit iffy right now, you know. But hey, you know, keep your head up and charge. Don't look at the elephants coming at you. And I operate with clean hands and in good faith. That's good. It's probably the only good part of what he's done so far. I take title to the matter. This is my title, property, matter, number, such and such. Instructions for the order. Number 1, discharge and pardon of final judgment in its entirety. 2, order foreclosure of this account number in its entirety. 3, order for expungement of case, costs. I call for all the coupons, the dedicate of the bond, and the voucher. 3 simple instructions. Release immediately to me in its entirety, including but not limited to the voucher to the bond. That would be the title. All the coupons and the certificates of the bond, all papers, tapes, CDs, recordings of any kind, fingerprints, photographs, phone logs, paper clips, rubber bands, sticky notes, any and all kind, known and unknown. Didn't ask for the garbage. Toothpicks and chewing gum, too. Return immediately to the following address. Da-da-da-da-da-da. The property of the Dodge van that was taken by the officer and towed by the transportation company without my permission. I think they took an unregistered vessel. I think they did. They found a pirate on the river of Tar and took his vessel. It wasn't registered. Had no flag, and he wants it back. Just like them damn pirates, ain't it? I know. I hate when they do that, too. Return immediately the $1,000 bail that was required of me to get out of jail. And the messenger service delivering this has been instructed and will collect these items, I'm sorry, I'm snickering, from the clerk of court on receipt. Please have them ready. Okay. Now, here is what you put across the 7 pages that they served on you. You're not taking notes, Caleb. Well, he's got a recording. That's why he ain't taking notes. Yeah. Okay. So turn your volume up. You don't want to miss what you put on your documents. Your offer of contract for subject matter jurisdiction is hereby rejected and returned to you unsigned in full accord with truth in lending. So let's get this straight. He isn't accepting anything, and he isn't authorizing any settlement, and you don't have my energy to close out the fiction, which I'm going to argue. You are ordered to prove up the claim or cease and desist. Show me your idol. I won't believe in your idol until you produce your idol. That's what he's saying. Produce and release the order of the idol and the bond of the idol to me. Pay all bills and close all accounts with regard to the idol. Any further correspondence from the sender or signers or agents or heirs or assigns of the idol must be signed under the penalty of perjury per IRC 6065. If you or your agents, heirs, or assigns are representing me with respect to your idol, or assuming you represent me with respect to your idol, you are hereby discharged. I can represent myself to your idols. Without dishonor, without prejudice, and without recourse, then he signs his name, the principal. What part have we just dispersed the idol? He's arguing with the idol. He's made it real. Now that fiction will come back to haunt him. However, he did have a deficiency notice. Now you can appreciate the deficiency notice, wherein it says the bond, the title of this case, cannot be released to a fictitious person. Exclamation point, yeah. Hello, bold, big point, big font here. It's not in italics because it was printed out. It wasn't even done on a typewriter. He actually got it printed by a living person's hand. Living persons are saying, hello, idiot, wake up. Okay? So that made Victoria's weak. She says, I'm going up there. They can't understand why they're going to jail in Alaska. She probably ought to stay there a month. Maybe. Yeah, I don't know. Anyway. Okay, so that's what's going on there. Now, we started a little bit late. I have been telling a number of people that I was going to read this transcript into a Monday night now for months, and I haven't done it. And it's very important for Victoria, and it's very important for a lot of other people dealing in their cases. This is a transcript of a recording of Barton Butts out of a seminar that he did earlier this summer out west, summer of 2003. And Barton is probably kind of the king of dealing with these responses in using asset tenders where the other party sometimes wants to come back and try to bring a presentment back to you to get you to argue whether or not your instrument is valid or not. And Victoria, if you will recall, tried to buy a car, tried to buy a house, tried to buy a number of things, and the instrument got as far as the bank of the beneficiary, and it seems to kind of just languish in that bank because they don't do anything. But in Victoria's case, they actually got good vibes back from the bank, and the bank said things. But then later on, when the proper responses weren't given, the bank just clammed up and went silent. So here's a little story that is told by Barton Butts, and it will help give you the answer to part of these problems. Barton is saying a very interesting situation existed last year in Arkansas. There was a gentleman that Barton calls Mr. Yancey, owns property in Arkansas, and a guy in California is retiring and moving to Missouri. But he made a deal with Mr. Yancey. They signed a contract took it to the bank, Arkansas State Bank. Mr. Abbott, who is the president of Arkansas State Bank, he okayed the contract. Now it is authorized by the bank. Mr. Moore from California gave a bill of exchange to Mr. Yancey for the property. Mr. Yancey took the bill of exchange to Arkansas State Bank with the instructions to send it to Mr. O'Neill, who at that time was the Secretary of the Treasury, which Arkansas State Bank did. And the authorized bailee